Hello, this is Dr. Advocate Sheetal Babar, and in this session, I shall be discussing about domicile. In my earlier sessions, I have discussed about a will, kinds of will, execution of a will, as well as construction of wills. Now, how are we dealing up with will again when we concern to domicile? Of course, because domicile is definitely a concern when we're talking about a will. The testator who has an intention to devolve his property should be domiciled in a particular locality to make applicable those rules for distribution of the property is the concern. Especially when we're talking about Chapter 2 of Indian Succession Act, it deals up with the relation between wills and domicile. It specifically only talks about domicile, but whenever, in furtherance to this act, we go ahead with the testamentary succession, we always look back to these rules of domicile and make them apply in respective situation. Let us talk about these situations. Let's say I have made a will. I'm the testator who's died, domicile being in India. I have two properties under my will. One property is located in England and one property is located in India. The question remains is what about that property which is located in England? What are those laws? Sure, the answer is simple. As per Section 5 of Indian Succession Act, we get all of these answers. Let's go into detail later on, but let us find out what this domicile exactly means. Unfortunately, Indian Succession Act does not define domicile, which though remains a major part for interpretation of everything concerned to testamentary succession. However, to understand what is domicile, let me give you a simple answer. Domicile is nothing but someone's fixed habitation or someone's fixed residence. It is nothing but an intention of an individual to reside somewhere forever. That is one of the modes we say to acquire a domicile. And trust me, we need this domicile everywhere, anywhere these days. So, simplifyingly, domicile is nothing but the intention of the person, which is declaration of his intention to reside in a particular place forever or for rest of his or her life. Now, when we're talking about domicile, especially Chapter 2 of Indian Succession Act, we shall be dealing up from Section 5 to 19. Though under this session of mine, I shall definitely not be caring about the sections and dealing up the sections. I shall be conceptually making you understand what this domicile exactly is and how is this applicable in certain situations. Section 5 of Indian Succession Act specifies two kinds of properties and its concern with the domicile. It talks about movable property and immovable property. Immobile property is always regulated by law of India. So say for example, I have a property which is located in India and which specifically is immobile. So wherever I might be domiciled, this property which is located in India shall be dealt up with law of India. It discusses later part as to immobile property. Now here the concern of the individual or the testator's domicile is must, because whenever there shall be a concern of immobile property of the testator, the place of his or her domicile is much of concern, because the law of that particular state where he or she was domiciled at his or her death shall make the laws applicable to that respective property, that is immobile property, only in context to laws of that particular state. So say for example, I have an immobile property located in Singapore. At the time of my death, I have acquired a domicile of Singapore. Definitely, in this context, as I being domiciled in Singapore, immobile property shall be regulated by law of Singapore. This is simplifyingly the complexity which has been dealt up by Indian Succession Act concerned to what property shall be dealt up how. And Section 5 specifies that it all depends on domicile when it comes to immobile property, because if it is concerned to mobile property, if it is a mobile property, definitely if it is located in India, only law of India shall be applicable. The next question to be answered is, are there any kinds of domicile and how many number of domiciles can be acquired? The answer for the latter question is there can be only one domicile as per section 6 of Indian Succession Act. So one individual, one domicile. There cannot be two domiciles, and wherein the complexity gets more complex or complexity gets more confusing. So one person, one domicile as per Indian Succession Act. The earlier question which was raised, are there any kinds of domicile? Rather, I would say there are modes of acquisition of domicile instead of calling them as kinds of domicile. These are kinds of or modes of acquiring domicile. There are three major kinds or three major modes which are discussed under Chapter 2 of Indian Succession Act. First is domicile by origin or domicile by birth. Second is domicile by acquisition or domicile by choice. And lastly, domicile by marriage. Let's come to first point. When we're talking about domicile by birth or domicile by origin, the Act further classifies the situation into two. It talks about the legitimate child or legitimacy and illegitimacy as the incidences. So, in case of domicile by choice, domicile by birth or by origin, and the context is about a legitimate child, the domicile of legitimate child shall be automatically the domicile of his or her father. In case if this child is born posthumously, that means after death of his or her father, then automatically the domicile of father at the time of his death shall be followed. In case of illegitimate child, mother is the concern. The child shall follow mother's domicile in case where the child is illegitimate. So this is what by origin or by birth. Let us move on to second kind, by choice or by acquisition, we say. This is where we talk about a situation. Say for example, I am the one who is by origin Indian. However, I want to relocate myself in one of the states of USA. And I have made up my mind to reside there forever. I have made a choice of my fixed habitation as one of the states of USA. In this case, by choice, I can make application and can follow the procedure laid down by that respective state, which gives one of the consequences that my earlier domicile will be automatically cancelled due to me acquiring a new domicile by my own choice. So this is what domicile by choice is. Third kind of domicile is domicile by marriage. Now this is something I say bit of gender discriminatory, but Indian Succession Act section 15 deals up with domicile by marriage, wherein it talks about the female gender. It discusses the provision that wife's domicile shall automatically follow the domicile of her husband. Vice versa is not the situation here. So, Section 15 of Indian Succession Act specifically talks about dependency of this incidence of marriage will alter the domicile of wife. She shall, after marriage, follow the domicile of husband. However, there is also one of the incidences wherein she need not follow her husband's domicile and she can acquire domicile by her own choice. In case where she is following or she's growing up with the decree of the court having the jurisdiction declared separation. So, decree of separation is one of the incidences where the wife need not follow the domicile of her husband. Indian Succession Act Chapter 2 also deals up with two more, I won't say modes of domicile, but kinds of domicile. Section 14 and Section 16 talks about two categories of individuals of whose domicile is to be discussed. One is domicile of minor and second is domicile of lunatic. Domicile of minor shall always follow domicile of his or her parent in respective situations which we've already discussed as to legitimate and illegitimate child. And unless and until the minor is has attained the age of majority, we say he or she cannot acquire a domicile by his or her own choice. Similarly, domicile of lunatic is also onto the same footings. Lunatic shall never have, as per Indian Succession Act, his or her own domicile. It shall always follow some another person's domicile. And who is that another person? In practice, it is always the legal guardian who is in charge of this lunatic. So this is all basically what we talk about a domicile, what we discuss about a domicile. Domicile, acquisition of domicile, provisions of acquisition of domiciles depend on to state situations. If you're talking about a domicile, acquiring of domicile in state of Maharashtra, you can acquire it from collector, you can acquire it from a tehsil office. There's certain procedures to be followed. There's certain documents to be submitted. However, everywhere in India, wherever you go, you ought to have a proof of your residence at least for 1 year prior of making this application. So you at least have to be a resident of that particular locality for 1 year, and only after that 1 year you can proceed for the procedure of acquisition of domicile. 1 year is not the minimum or maximum criteria. It is the provision which states in the preceding year you ought to be staying in that particular locality where you want to apply for a domicile. So this is all about the domicile. This is all about what Indian Succession Act talks about the domicile. But why does it talk about a domicile and how it is concerned? Where is it concerned? It is concerned especially in context to testamentary succession. There are many more chapters wherein we need to go back and read chapter 2 and we discuss domicile. Now in this context where we're discussing about domicile, it is actually concerned for testamentary as well as intestate succession. However, when it comes to testamentary succession, as in earlier sessions we've already discussed this, it is a fresh um, thing into our mind. Hence, while applicability of norms or rules for distribution of the property, we say we need to see the domicile of the person, because domicile of an individual who's owner of a particular property, his legal declaration under a will, her legal declaration under a will, and the locality or where that particular property is situated, what kind of property is it, all are interlinked, and hence domicile plays two vital role when it comes to disposition of any kind of property in any ways, may it be a testamentary or intestate, under Indian Succession Act. One more thing before I leave. When it comes to Chapter 2 of Indian Succession Act, It is definitely, and it is very specifically mentioned under the Act. Applicability of this chapter is not to Hindus and Muslims. And why is that so? Because when it comes to any kind of succession concerned to Hindus and Muslims, there shall be a preference to the personal laws rather than to any secular or any another laws. Unless and until personal laws are suffice to inheritance or succession, we cannot deal up such kind of distribution of property by any another laws, and hence when it comes to chapter 2, it is not applicable specifically under the clause of applicability of this chapter 2 of Indian Succession Act. It is not applicable to Hindus, including all of those under the definition of Hindus and Muslims. So, this is all from my side for and in regards to domicile. Thank you.